Hey everyone, good morning. Welcome once again to Fitz in Law School. I'm Fitz, and I'm thinking today about contracts, mostly because I have a final tomorrow. So I thought that we would talk a little bit about a couple of subjects within contracts that I would like to talk about. I also think they're going to be on the final tomorrow. But also they're just some of these kind of interesting, slightly outside concepts that we really focused on this semester. So just getting right into it. First of all, contracts are a pretty interesting class. You might hear horror stories about that class in general from people who are, past that or taking it right now or something. It's a complicated subject. It's cases that you read are super technical, and a lot of times they're about things that aren't, like, the subject matter isn't quite a story as much as it is focusing on the technicalities. Like, even civil procedure is a little bit more about the story than contracts is. Torts is all about the story. Torts is all about, just kind of what happened in a sequence of events, versus contracts, it's inherently slightly more mundane because it's talking about the technicalities of the written word within a document or lack thereof. So yeah, but don't let that encourage you, or don't let that discourage you, because I think that's a very interesting subject. So give it a chance, all right? Trust me. Okay, so we're going to be talking about three things today. And the first thing we're going to be talking about is the parole evidence rule. Okay, so parole, spelled P-A-R-O-L, no E at the end. So this is not talking about people who are getting out of jail on parole. No, this is entirely different. So the parole evidence rule is essentially a rule in which it's the rule dictating when you're trying to figure out what a contract says, what it means, how to explaining a contract, supplementing a contract, adding or subtracting terms. It's things that are outside of the contract. So you have, like, a lot of times, some courts will say the four corners of the particular contract. That means that you have a piece of paper right here. What does it say in that piece of paper? Anything else outside of that, not allowed. Okay, so the parole evidence rule is essentially talking about when can you bring in outside information or outside evidence to add, subtract, explain, whatever, to this contract. And there are a couple different situations in which you can and which you can't. And a lot of times it mostly means that you can't. You can basically always bring in outside evidence when you are trying to explain something in the contract. When there are terms in the contract that are ambiguous, we have no idea what this means, what do we do? Then someone goes and says, well, here's an earlier writing, or here's a trade usage or something like that. Everyone in the industry does it this way, so obviously this is what we meant, that kind of thing. And so that's when you can kind of bring them in. But essentially there's kind of two classes of contracts that we discussed anyway in this semester. Two classes of contracts which kind of interact with the parole evidence rule. One is a fully integrated contract, and another one is a partially integrated contract. So integrated essentially means like it has a merger clause in it, and the merger clause is the thing that says, you've probably seen this in contracts all the time, that it's usually like a short paragraph. It's pretty standard, and essentially what it says is, no other agreements, either oral or written or whatever, inform the contents of this contract. So that's essentially what it's talking about, or what it's referring to when it says those kinds of things. It's referring to the parole evidence rule. It's referring to anything that you're looking for, any sort of interpretation that you're trying to figure out or whatever, is only in this contract. So if we had an email back and forth saying, oh yeah, you can, let's like take a lease or something. You can, I don't know, put hangings on the wall, right there we go. You can put hangings on the wall, and that was something that was not in the, or it was like, yeah, so you can put hangings on the wall. That's what you discussed in your email, and then in your lease, it says you can't do that. And so then the person goes and says, when you're moving out, they go and they say, oh, sorry, you need to pay $500 in order to repair the wall. And then you say, what the hell? I know our contract might have said something. However, we had outside communications outside of the contract that said I could. So you shouldn't be able to collect from me. And so then the landlord would point to that contract and say, no, we never modified the contract, and the contract itself says that nothing else is included. And so you're out of luck. There are certain ways to get around it, but that's basically what it is. A partially integrated contract is essentially that. It's something that's partially integrated, or it's like piecemeal made of different things. It's an agreement that might not have a merger clause. It's lots of different things that probably could make it integrated or not. And so that's where it's just slightly more acceptable to put in different things. However, partially integrated usually actually only means that you can either supplement things that are in the contract or you can explain. For a fully integrated contract and a partially integrated contract, you can always explain things, okay? You can't modify them, you can't change them, you can't subtract them, you can't do anything about that, but you can explain in both purposes. For the partially integrated contract, you can supplement things. Saying, I know this is what says the contract, however, this contemporaneous writing or how we were performing the contract throughout the entire process kind of says this is what we actually meant. And so the contract might not say it properly, but we have been dealing with it like it's that way. And so a court would essentially take those outside writings, performance, whatever, and kind of put it together and say, okay, this is kind of the new contract. For the purposes of this lawsuit, we just made a new contract. That's including this kind of outside stuff outside of the contract, if it's a partially integrated contract. So that's the parole evidence rule. It's not difficult to understand. What is tough is deciding when you are able to introduce outside evidence. That is a little complicated. The next one is a big thing called promissory estoppel. So promissory estoppel is it's probably triggering something in your head, and you can probably kind of try and figure it out. Promise. But that's something that's harped on all the time in lots of different cases. But essentially what it is it's the concept where if there is like an oral agreement or a contract is never really signed, how can you make that promise legally enforceable? So we read a case that was talking about a woman who was the daughter of this family and who grew up, and the family owned a bunch of land and stuff, and the dad throughout her entire life was saying, hey, when I pass or when I don't know, when you come of age or something like that, then all this land will be yours, straight up Lion King kind of a thing. And she said, okay, fantastic, blah, 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 blah. And then she started to, not only was she regarded that as she was being told for years that promise was in fact going to happen. Then she grew up, she got married to this guy, then they had a trailer that they moved into on the land, and then they started building a house on that land. The dad was helping them go in and build the house on the land, help them get the lease, help them get the permits, all these kinds of things. And then he reneged on that promise, and he said, you know what, actually no, I don't really think so. And I think it had something to do with the daughter's husband died, and then she got a new partner, and the speculation, I think the partner was a woman or something, and the dad had a problem with that, and so he decided to not do it anymore. And so she sued him for that property and that lease and all that stuff. The house was done and everything like that, and then he just said, no, sorry, you can't live in it anymore. And so there was no contract ever signed, but what there was promissory estoppel. There was a promise continually solidified and then acted upon, and all that stuff happened, and they said no. And so and so kind of the big parts about it are a clear promise that someone has made. You have to be able to point to it and say, look, these terms were unambiguous, you promised me this, and all that stuff, and then you reneged on that promise. That's not cool. Another thing that has to happen is that the promisee, so the person who's getting promised to, not the promisor, the promisee, they have to rely on that promise in some way to their detriment or to their benefit, depending on there was a super interesting so for the land case that I just talked about, that the woman like went and spent a lot of money building the house and all that stuff, and so that was a clear detriment to her, that she was relying on nothing more than the promise. There was no contract or anything like that, and so she spent a ton of money to build this house, and then had the rug pulled out from under her. And so because of that, that was relying on the promise to her detriment. Now, is that something that's required? No, it's not something that's required, because there's this other really, really interesting case. This was essentially talking about a guy who, and this was a long time ago. This was a really old case, but it was something that's like pretty common for a lot of first-year contract students to read. Is this guy in New York? He went and he promised his nephew or something like that, his nephew or his grandson or whatever. He promised to give him, and this was back in like the early 1900s or something. So it was something like a plot of land and like 20 sheep or something like that. And he said that if you get to your like 21st birthday or something like that without smoking, drinking, gambling, and I don't know, like getting good grades or something like that. I don't know. So essentially, if you forbear from a couple of these certain things, then I promise to give you, these things. And the court examined that and said, okay, the concepts of promissory estoppel are relying on a promise to your detriment, okay? And the guy's lawyer said, well, these weren't to his detriment. He's healthier because he didn't forbear from these things. So therefore, no, promissory estoppel is not applied. And so the court said, no, I don't think so. I think that it's going to be you have to either rely on it to your detriment or forbearing from something that is legally your right to do. He had, the kid had the legal right to, once he hit a certain age or whatever. This was a long time ago, so it could have been like 16 or something. He could smoke, he could drink, he could gamble, and yet he decided not to because of that promise. So because of that, the court decided to enforce the promise. So it's super interesting. And then a last part of the requirements for promissory estoppel is that there's no other way to get justice unless you enforce that particular promise. And so that's where it's kind of an interesting thing, that it's not like a damage or something like that. You can't just say, just pay them money and then they'll be good. It's when enforcement of that promise is really the only way to do it. And so like in the land case, it was essentially saying, they put their heart and soul into, and they had a huge amount of detriment stuff about building that house. And so in order to go and like the clear justice here is to give them the house and the land, because that was what the entire process was all about. Promissory estoppel is super interesting, and you'll see that all the time in cases. And that's definitely going to be something that's on the test, and that's definitely going to be something that kind of like should be in the back of your mind that, okay, a contract was formed. Was it formed? Yes or no? Was it accepted? Was an actual offer? All those kinds of things. And then if it wasn't, okay, what's like the next step? Well, okay, was there like a clear kind of bargain negotiation kind of a thing, and then was a promise made, and then was there some sort of detriment to that promise, or reliance on that promise that was a detriment to the promisee, and all those kinds of things. But that's always kind of like a secondary thing if you have a contract, or if you don't have a contract, then that's the first thing that you should be paying attention to. But yeah, it's super interesting. And then last we have the statute of frauds. Okay, so the statute of frauds is a pretty, again, it's not confusing, it's just that it's kind of a backwards-ish kind of a thing, kind of concept. So what it is it's basically like, it's actually kind of a good idea to talk about the history a little bit about that statute. So what it is it came from this statute in England, I believe, but the original name of the full statute was Statute to Prevent Frauds and errors or something, and issues, or it was something like that. But just think about it that way. Statute meant to prevent fraud. Okay? So what that means is that there are some contracts within the realm of contract law that this thing requires them to be in writing, completely in writing, okay? In other words, if it's an oral promise or something like that, that's not enforceable. So if the statute of fraud applies, then that means that in certain cases, certain types of contracts essentially have to be required to be in writing in order to be enforceable. If they're not, then they're not legally enforceable. And so, yeah, just think about the thing. If it is within the statute of frauds, then if it is written, then it is enforceable. If it's not written, then it's not enforceable. But that's if the statute of frauds applies. It's weird. So there, I mean, it's kind of basic stuff like a marriage contract. That's a contract that you sign. It's a contract with the state that you sign. That has to be in writing. Selling land, like an interest in land, has to be in writing. Any sale of goods over $500 has to be in writing. Any contract that takes more than 1 year, unless of course it's an indefinite contract, then it doesn't have to be in writing. Even if the performance of that contract takes more than a year and less than 1,000 years or whatever. And then it also kind of works with kind of modified contracts. And so a classic modification is that you're leasing a car for 9 months, and so you can lease that car and it's for 9 months. And so you say, all right, sounds good. It's not kind of under the umbrella of the statute of fraud, so it doesn't necessarily have to be in writing in order to be enforceable. However, let's say you have the car for 2 months or something like that, and you say, wow, I really love this car, and then you go and you communicate with the person, say, just by email, and say, hey, I really love this car, I'd like to extend my lease by another 6 months. So that means that it's 15 months. So because it's 15 months, now the statute of frauds applies. So that means that now you have to have it in writing in order to be enforceable. And the same is true for the opposite. If you are leasing a car for 12 months or for 13 months, and then you say, wow, I hate this car, then originally it was under the statute of frauds, and then you modify the contract so that it's not, so that you say, okay, I only want this car for 3 months, then now it's not in the statute of frauds. Stuff like that. And so those are kind of like three of these kind of outside concepts that we were talking about, in addition to all the classic stuff within contract law. Was it a contract? Was there a bargain? All these kinds of things. So it's a very, very interesting type of law and all that stuff. Yeah. But let's see. It is holiday season. It is final season. It's all the stuff going on right now. I'm sure you are loving these bags under my eyes. But let's see. Talking about next week, I'm not sure. You know what? We're going to talk about, because let's see. So I have 3 finals. I have 1 final this week, 1 final next week, and I've already taken 1 final. So I think that perhaps next week we are going to talk about finals. Because I'll have that under my belt and I'll, get that all settled, and I'll have 1 semester's worth of finals under my belt. So we'll talk about that then. All right. See you, everyone.